Okay, so have I finally figured out how to make this into the full screen? I'm not quite sure why it took me uh, like 4 chapters in to fix this on my laptop. But I did, I think, finally. So, hi, Crim 1, Chapter 7. Legal issues in policing. The Fourth Amendment. Search and seizure. The Fourth Amendment is something that protects all of us from unreasonable searches and seizures. What is a search? I think that one's really easy. Anytime someone in law enforcement or a government official, but typically we're talking law enforcement, searches us, either our person or our property. That's a search. Or a seizure can be basically a seizure of your freedom. So anytime you're taken into custody without cause is an unreasonable seizure. So yeah, we are protected against unreasonable search and seizure. And that basically means that, hey, stop it. Sorry, my dog is sitting here like licking, making noises. It drives me nuts. So we are protected against unreasonable search and seizure from police. Police officers cannot just randomly walk up to you and search you unless they have, except for under certain circumstances. And we're going to talk about some of those right now. Oh my gosh, now he wants out, the dog. He's killing me. Hold on, I'm going to pause you. Okay, I let him out. Technological advances make it difficult to determine the scope of the Fourth Amendment. Can your computer be searched? Can your phone be searched? That's kind of what we're talking about when we talk about. Oh my gosh, did I just pause that and start it over again? I just did. I hit the wrong. Anyways, hi, we're back. Okay. Next slide. Reasonableness. The government must obtain a warrant before its agents can conduct a search or seizure. Okay, that is not exactly 100% all the time true. Is a warrant always required? No, a warrant is not always required in order for a search to take place. There are some instances where you do not need a warrant, but a warrant is always a good idea if you are a law enforcement official and you have time to get a warrant. It's a good idea to get a warrant. If you do not have time to get a warrant and you have some other circumstances exist, you might not have to have a warrant. However, it is always a good idea to get a warrant if you can. Okay. Typically, in order to get a warrant, you have to have probable cause, and a judge would have to sign a document written by this law enforcement or government official in order for a person to get a warrant. A warrant is a written document that basically lays out probable cause, why the warrant is being issued, why you are asking that something be searched, and what they're looking for. And the judge typically will sign this document if the judge finds that there's probable cause or enough evidence for that warrant to be signed. What is reasonable? And typically this lecture that I'm going to go over in like 20 minutes will take me days in class. So this is really fast. We're going through this really fast. I hope that you will take the time to read this chapter and or at least read these PowerPoints, because there's a lot of important information in here. Exceptions for the need of the warrant. There are a lot of them. Government agents do not need a warrant if it would endanger public safety. So if there's some sense of urgency, let's say a person has kidnapped someone, they are holding them at gunpoint and they drag them inside a house. Would the officer need to get a warrant to enter that house in order to try and save the kidnapped victim's life? No, there is a sense of urgency there. The person is being kidnapped and dragged into someone's home. Are you going to wait to get a judge to sign a warrant in that case? My gosh, I hope not. Okay. Felony arrests do not require a warrant if there is probable cause. Probable cause. Misdemeanor arrests with or without a warrant do require probable cause. Terry stop is also called a stop and frisk. This is a really controversial type of a search and a brief seizure and or detention. This is based on a case that took place in Ohio. There was a police officer who'd been an officer for many years. I believe his name was Officer McFadden, and I remember that because one of my partners at Hoover was named Officer McFadden, my first partner. And Officer McFadden was patrolling an area where there'd been a lot of robberies. And he's a very experienced officer, and he'd been watching this area for quite some time, and he saw some suspicious behaviors. He saw a group of men, I believe there were 3 of them, walking back and forth and back and forth and back and forth by what was like a jewelry store, pawn shop, something like that. There'd been a lot of robberies, like I said, in this area. He was a very experienced officer. He thought that the suspects were behaving in a way that seemed suspicious. He also thought that maybe the attire they were wearing was suspicious, in that he thought that there was a possibility that they could have been hiding a weapon in whatever their clothing was. So for officer safety purposes, Officer McFadden stopped these suspects and patted them down for officer safety purposes to make sure they didn't have any weapons. When he patted the suspects down, he found guns, and they were arrested. Ultimately, that case made its way all the way up to the Supreme Court because the suspects said that he did not have the right to search them because he didn't have probable cause. Well, the court found that because of the dangerous nature of police work, and because he had at least reasonable suspicion to believe that something was not right. I mean, he was in a high crime area where a bunch of robberies had taken place. He was a very experienced officer, and he was suspicious that these guys might have been casing a store by the way, because of their behavior, walking back, forth, that it was reasonable for him to pat them down for officer safety only. A Terry stop is only a stop and frisk for officer safety purposes only. So he can only pat them down to see if they had weapons. If he felt something that felt like a plastic bag with drugs in it, he could not pull that out. If he felt something that felt like a hard firearm or something like that, yes, he could pull that out. So that's what a Terry stop is, stop and frisk. There is an exception for automobiles, not always, sometimes. Sometimes officers are able to search some vehicles based on probable cause without a warrant, only because automobiles move, right? They're easily moved. Now, does that mean a police officer can pull you over for a traffic violation and search your whole car? No, not without probable cause. So don't let that happen to you. Search incident to an arrest. If you are being arrested for something else, can the police officer search your wallet or anything around you that you had access to? Probably yes. Can they search your backpack that was locked up in your locker at work? No, because you didn't have access to that. But so there's all kinds of interesting law, and these laws change a lot with new court cases that happen. If evidence is found, or if police officers do an illegal search, any evidence that is found during that illegal search is subject to the exclusionary rule, meaning it will be excluded from court because it was seized illegally during a search. My favorite example, let's say I got a warrant, okay? I actually went through the steps to get a warrant to search a house, and I am looking for an intact dead body. You're wondering why I say intact, okay? The body is in one piece. It is a dead body that I'm looking for inside a home. While I am searching inside that home for an intact dead body, I open the medicine cabinet and I find a bunch of cocaine. Is that cocaine going to be allowed into evidence against that suspect? And the answer to that question is very likely going to be no. Why? Because why on earth would I look inside a medicine cabinet for an intact dead body? A dead body would not fit inside a medicine cabinet, so I couldn't look inside a medicine cabinet for a dead body. Right? Right. Exclusionary rule. So anything seized by law enforcement illegally is subject to the exclusionary rule. There are exceptions. There are exceptions to the exclusionary rule. Typically, those are things like the officer conducted a search in good faith. Things like, and this has happened before. People have called when I was working for probation. Like, hey, I got, Johnny with me. He's still on probation, right? And I would say, yeah, I'm looking him up right now. They're like, is he open to search and seizure? And I'm Johnny's probation officer. And I say, yes, he is. He absolutely is. And they're like, okay, I'm going to search his house right now. Okay, go ahead. Okay. And then I find out, a week later that, there was a clerical error in, Johnny's probation conditions, and I was wrong. His probation had actually terminated the week before the officer did the search of his house, but while the officer was searching his house, he found a dead body in Johnny's house. Was that a good search? It was. The officer did everything right. He called me, Johnny's probation officer, to make sure he was still on probation. I looked Johnny up in my computer system. As far as I know, Johnny's still on probation. So it was a good faith exception. Everybody did what they were supposed to do. It's just a random clerical error. So that would probably be an instance where that search would still be good, even though it really wasn't a good search. It makes sense. It was a good faith exception. Everybody was doing the right thing. It was just an accident. Mapp versus Ohio is probably the first case where the exclusionary rule was applied to state courts. Dalry, that must be her right here. Dalry Mapp got arrested for having officers. If you've ever seen the movie Training Day, there's a scene where Denzel Washington basically hands a Chinese food map to Macy Gray. It's Chinese food, not map, menu to Macy Gray, claiming that it's a warrant. It's not a warrant, obviously. And then they just march in and they like toss her house and they steal money from her. Basically, almost the same thing happened with Dalry Mapp in like the 1960s, but it was just a blank piece of paper. They walked in claiming to have a warrant. They didn't have a warrant. They were looking for a bombing suspect. That's not what they found. They found pornography, which was illegal at the time. Dalry Mapp was convicted for possession of pornography. And then ultimately, she took a case to the Supreme Court, and they decided that because there was no warrant, it was a fake warrant, they overturned her conviction. I'm going to kind of skip that. Okay. Okay. Yeah, defendant's rights were not violated, does not have standing. I'm going to kind of skip over that. But the knock warrants and no knock warrants, these are tough ones. There was, oh gosh, now I'm a horrible person because I can't remember her name, but there was just a beautiful young lady who was shot and killed by police. And it was a warrant. And her boyfriend shot at the officers. They shot back and killed her. It was one of those times when they started, I think police officers have started to consider whether or not no-knock warrants are something that they want to continue doing. there are knock warrants and no knock warrants. A knock warrant is basically when officers are required to pound on the door and say, police, we have a warrant, we're coming in. And they knock on the door, you know, knock warrant. And then a no knock warrant is basically when they kick the door in and they bust in and try and surprise people. Okay, no knock warrants are obviously pretty dangerous. Bad things happen or can happen during a no knock warrant. People die. It has happened before. People don't know who's busting into your house, if it's a police or if it's a bad guy. And if you're the police, you better hope and pray you got the right address, because mistakes happen. Why would you have a knock warrant versus a no knock warrant? You know, no knock warrants basically are, a lot of times they're trying to find drugs during the no knock warrants, and people will get rid of drugs if they have the opportunity. They'll flush them. They'll do, you know, God only knows what with the drugs if they know that the cops are at the front door. So some warrants will say no knock warrant on it, or they'll specify certain dates or times when people are allowed to serve the warrant. Fifth Amendment is, you've heard the phrase, I plead the fifth. The Fifth Amendment basically gives you protections against testifying against yourself or incriminating yourself. You do not have to talk to the police. You do not have to testify against yourself. Miranda is probably the case that we all are familiar with. You know, you probably know your Miranda rights. You have the right to remain silent. Anything you say can and will be used against you in a court of law. If you do not, you have the right to an attorney. If you cannot afford one, one will be appointed for you free of charge. A lot of the things that people forget here is that typically, once you say, I understand all those rights, you have to ask, do you want to waive those rights and talk to me as a police officer? So anything that a person says has to be voluntary, and the officer has to make sure that the person actually understands their rights and that they agree to waive those rights. So nobody can be forced to testify against themselves or say anything against themselves. The only thing you really have to do when you're dealing with police is identify yourself and provide proof of identification. And there is Mr. Miranda himself. He was a murderer, and he was questioned by police, and he claimed that he did not know that he didn't have to answer the police officer's questions, so his confession was tossed. And thanks to Mr. Miranda, we have our Miranda rights. And that was in Arizona in the 1960s, I believe. Yeah. So if you, every time a person is detained and questioned, they are to receive their Miranda rights. Detained and questioned. And yeah. You have the right to remain silent. You have the right to consult an attorney. And you can at any time stop talking and consult a lawyer at any time. I like, let me see, okay. There's a case that I was in, well, not that I was involved in, but again, working at Hoover, we had a fight that happened on campus. It wasn't really a fight. It was during class, so the hallways were pretty clear. And it was a young man, I don't know, 15, 16 years old, does like a full-on Superman punch, goes flying through the air, Superman punch, punches this girl in the face in the hallway, in front of a couple of campus assistants, at least one who saw the whole thing happen, and in front of a video camera. So there was at least one or two physical actual witnesses. There was video of the actual crime taking place. Okay, so myself and my partner, my police partner, go out. I grab the girl, the victim, take her to the nurse's office. You know, she's crying, she's bloody, all that kind of stuff. My partner, Officer Underwood, takes the suspect, takes him into our office, the police probation office. Okay, He handcuffs him, of course, probably chains him to the bar in our office, which is normal. That's kind of what we did. He was fired up. So we didn't want him to like try and, bust out of the office and do anything else crazy. So after I leave the victim with the nurse's office, I come back to our office. Officer Underwood is getting just his basic information, the suspect's basic information, name, address, date of birth, calls the suspect's mom and says, just want to let you know, I've just arrested your son and I'm taking him to juvenile hall. Okay. So then the kid is clearly in custody. Okay. He's got cuffs on and has already heard we're taking him to juvenile hall. Okay. So we walk him to the police car, put him in the back seat. Let's say it's August. So it's very hot. The back of the police car, not a comfortable place. It is, black plastic, kind of like plasticky. It's hot and miserable back there. The kid's sitting back there and I look at him. I'm sitting in the passenger seat. Officer Underwood is in the driver's seat. The kid is in the back. I look back at him and I say, can you feel the air conditioning? That's all I said to him. Can you feel the air conditioning? Because it was really hot. And the kid said, yes. I said, okay, let me know if it gets really hot. Because I don't want the kid to, stroke out and die in the car on the way to the, juvenile hall because it was really hot. And then about a minute later, the kid said the bitch deserved it. Okay. Nobody had Mirandized that kid. Why? Because there was no need to. There was witnesses, there was video, there was all kinds of stuff. It was like, why bother? Why bother? Nobody needed to Mirandize this kid. It was a pretty clean-cut case. Victim, video, several witnesses, the whole bit. Why? Nobody needed to question the suspect. Was there a violation of Miranda? No, there isn't, because I didn't ask him anything. Nobody asked him any questions. You need to be Mirandized if you're in custody and interrogated. Both of those things have to happen. Both of those things have to happen. And again, are there exceptions to Miranda? Same kind of deal with the last one. Public safety exceptions is something, if somebody's going to die if I don't ask someone a question right now, then there's an exception to the Miranda rule. Otherwise, pretty much not. Sixth Amendment, we have a right to counsel. You have the right to an attorney. Anytime the proceedings become accusatory, you have the right to an attorney. Use of force. Like I said, police officers are probably almost the only, besides maybe doctors and nurses, because sometimes they have to hold people down, EMTs, stuff like that. Probably one of the only jobs where you are allowed to actually use physical force in order to get someone to comply. Tennessee versus Garner. A lot of people, you may have even heard this in your life, about a fleeing felon. The fleeing felon rule. Oh, you can shoot someone if it's a fleeing felon. You can use deadly force against a fleeing felon. Oh gosh, I wish that phrase was never put out there, because that's really not the case. I mean, in certain circumstances it could be, but Tennessee versus Garner is a case where like a 15-year-old kid is burglarizing a house. And I think we talked early on about robbery and burglary. This is a burglary. This is a burglary. He's burglarizing a house. And the police are called, and the 15-year-old kid is jumping the back fence trying to get away, and an officer shoots and kills him. Is he a fleeing felon? Yeah, he's doing a residential burglary. It's a felony. Is it reasonable that as the kid's running away from a house that he's burglarizing, he's shot and killed by police? That's a big fat no. No, 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 no. Yeah, you can't do that. So anyways, that's definitely not the way things can go. Now, if he is pointing a gun at the officer as he's jumping over the fence, maybe, not a maybe, yeah. If he's pointing the gun at an officer, yes, the officer can shoot him. Different story. But this kid is literally trying to get away from the police after committing a residential burglary. Yeah, not reasonable to shoot in that kind of a scenario. So use of force is definitely a big, it's a big area of concern right now. Clearly, we see a lot of stuff on the news about use of force and police officers and whether they should shoot or they shouldn't shoot, or is it, should every officer tackle every suspect? And I mean, there's a lot of you that are probably, watching videos thinking, well, why didn't the officer shoot him in the leg? Officers aren't trained to shoot people in the leg. Why didn't they shoot the gun out of his hand? I want you to think about that. Imagine if I have a gun in my hand. Can I move my hand? Is that gun going to stay in the same place? If you're in a life or death scenario, are you really going to be able to aim at my hand? No matter how well trained you are? I mean, you got to think about that kind of stuff. Well, shoot him in the leg. If you shoot me in the leg and you hit one of my arteries, am I just as likely to die as if you hit me in the chest? I don't know. But I mean, you got to think about this stuff. Officers are trained to stop the threat. They're trained to stop the threat. They are not trained to shoot to kill. So these are things that the general public probably doesn't know. And it's frustrating because I think the general population thinks that police officers should be Superman at all times, and it's just not reasonable. Anyways, Graham versus Connor, I believe, is a case that talks about reasonableness. What is reasonable? What is unreasonable? This is a case where a guy is having kind of like a diabetic reaction. He needs to get sugar in his system. So he's really just asking his buddy to take him. He asks his buddy to take him to get some orange juice. They get in a car and they drive to the closest mini mart, gas station, whatever. And they get there. He gets out of the car. He runs up to the gas station or the mini mart, and there's a big line. He runs into it. He runs into the gas station. There's a big line of people. He panics. He turns around and he runs out. He hops into the car and they speed away. Well, across the street at the same time, an officer happens to see this. This is a high crime area where some robberies had taken place. The officer thinks that looks suspicious. Does that sound reasonable? I mean, it does sound reasonable. It's not what happened. It's not what was happening. But it was a reasonable thought for the officer to have. So officers pull the car over. They detain him. Unfortunately, the guy is sustained some minor injuries as a result. But this is a court case where the court found that what the officer did and thought was happening was reasonable. So they considered the totality of the circumstances and found that the officer was reasonable. Talking about the continuum of force, a lot of people will also argue that officers have to go through each level of their continuum of force before going to deadly force. This is not necessarily true. If someone walks into, let's say, a classroom with an assault rifle, do I have to, as a peace officer, do I have to start with my verbal commands and work my way up to deadly force when someone's pointing an assault rifle at me? Gosh, I hope not, because every officer would be dead if that were the case. You have to use the level of force that matches the level of the threat. Okay, so I don't have to use my verbal commands on someone who's pointing a gun at me. But, there is a continuum of force, and you should use the level of force that is reasonable for the scenario. What is the level of force that's necessary in each scenario to neutralize the threat? Might it be just verbal commands? Yeah, and if that's what it is, then use verbal commands. A lot of times that's all it takes. In fact, sometimes all it takes is for an officer to walk in the room. So yes, these are levels of the continuum of force. Sorry, I just kind of went through that really fast, but that's what they are. Mm-hmm. If you work for any agency, you should be well aware of their use of force policy, because if you do not follow their policy, they will throw you under the bus and you will get sued. And they will fire you. Yeah. I think that's it. And then I think there's part 2 will be next. Part 2 was recorded about a year ago. So sorry guys, but it still fits.